What is up? What is up, YouTube? Major mistake. Day 29, y'all. Day 29. I think Uncle Mike was off like a government worker on a Sunday. That's off. You know, when you're off on the weekends, you work for the government, you don't go to work on Sunday. Man, hey, I'll call y'all back. Hey, live from Diddy's trial, Diddy defense make major mistake that will cost him his freedom. God dang, they already made the mistake. They know good and well they paychecks about to run out with him. They already looking for new clients and stuff. Y'all hit that subscribe button. Hit that bell, baby. Let's check this bad boy out.
The courthouse, and we are talking about what is going on with Diddy. Baby, they are saying that Diddy has made a fatal error. His defense has made a fatal mistake that I am predicting, cost him everything. Now, baby, let's get into this, okay? Now, first of all, everybody's talking about this Rule 29 that Diddy did yesterday. He's getting out. Diddy made a Rule 29 motion. Y'all, listen, and I took notes, this is serious. Let's actually talk about what a Rule 29 motion. It is a motion for a judgment of acquittal. It is in the several rules of civil procedure. It's called something else in the state level, but we are talking about federal, right? It's a federal rules of criminal procedure, right? And it comes into play during the trial. Diddy is not expecting this motion to get granted. There is no basis for the motion to be granted, but they are setting it up for acquittal, all right? Rule 21 lets the defendant ask the judge to enter a judgment of acquittal. It is a legal not guilty verdict on the basis, right, that no reasonable jury could find guilt beyond a reasonable doubt. Now, y'all, you might not think Cassie's a victim. You might not think Jane's a victim. You might not think a lot of things. But the fact that you are going to sit here and act like they didn't show bribery, they didn't show violence, they didn't show drug trafficking, they didn't show... It's ridiculous. A reasonable jury could. The only way a Rule 29 would work is if y'all tried to get me for murking somebody in Kazakhstan and y'all see me on live outside the courthouse every day. You would say there is no way Tisa could have been in Kazakhstan, did that mess, and then came back in time, all right? Now, keep in mind that during the trial, at the end of the prosecution's case, which is what we're coming up, a defense attorney can move under Rule 29, arguing that the government has not presented enough evidence on one or more elements of the crime. You guys, if Diddy's team really thought the government didn't do, we're going to talk about the major mistake they made, but if they really thought that the government didn't submit enough evidence, they would have a litany of people marching in, testifying on behalf of Diddy. Now, they can only do this after all the evidence, right?
Right.
After all the evidence. Now, here is what Diddy is trying to do. So when the prosecution rests, the judge will rule on the Rule 29 motion. You can only do it once the prosecution rests and before defense starts there. Again, remember I said law is procedure? This is the procedure. However, you can renew this motion after the defense rests. So you get 2 bites at the apple. Unfortunately, it is a poison apple. It is what it is. And get this, you can do a post-verdict. They are setting up. Now, again, you must do this Rule 29 if you want to do all this other stuff. If you don't do a Rule 29 after the prosecution rests, you cannot do a renewal for a motion to dismiss after the defense rests. And you can good morning. You can 100% not do it after post-verdict. These are the rules. I didn't make them up. They're in the federal rules of civil procedure. So they don't expect Rule 29 to actually stand. That will be, no, it won't be granted. They will do it after defense rest, but it won't be granted because the defense just said that they ain't doing nothing but reading text messages. Remember how Diddy lied and told us they had a whole bunch of people and you're gonna see and they're gonna put an all-star? They were lying the whole time, just like they are lying now, right? Now here's where they think they're gonna get them. A post-verdict motion to dismiss later. If the jury returns a guilty verdict, okay? Rule 29C allows the defense to renew the motion within 14 days of a guilty verdict, asking the judge to overturn the jury's verdict and enter a judgment of acquittal. Now, why would they be doing this, right? How does this play later into dismissals, the post-trial motions after he gets a guilty verdict? So again, You must do Rule 29, whether it's rejected or not. You must have it on the books, right? They are rules of procedure. Then after the defense rests, right, you do a renewal motion for acquittal. And then if that's denied, after the jury comes back with a guilty verdict, you can actually go, within 14 days, you can do a 29C, a post-verdict motion to dismiss later. The post-verdict Rule 29 motion, which is 29C, acts like a last-ditch effort to get the conviction tossed before sentencing or an appeal. It is based on the exact same grounds, all right, as the mid-trial motion, which is 29C, or new reasoning, as long as it is about insufficiency of evidence. Now, sometimes this may be combined with Rule 33, motion for a new trial, especially if the defense is alleging procedural error, newly discovered evidence, or prosecution misconduct. Now, interesting enough, they are trying to lay the grounds for procedural error with the juror number 6 getting dismissed. That is why and again, I'm giving y'all the long view of all the dirty tricks they decided to do. They think that by getting, they didn't want it, but when juror number 6 got dismissed, Diddy and them thought this could work to their favor. They thought that the judge's ruling for dismissing him was very light. They can say it was some type of racism, even though that won't really play because this is one of the most diverse juries. There's people from every race, pretty much every race and creed on there. SS Augustine, thank you so much. There's people from all sorts. However, they are going to say that the judge had no right to remove the juror for lack of candor. And when they removed, that is when there became an issue of some type of procedural error. Mainly saying, because here's the thing, right? When you go for overturn, it's not enough to say, yo, you didn't show this evidence. Even on appeal, everybody thinks appeal is going to be the thing. Appeal is one of the hardest things to get. It's not enough to say, right? It's not enough to say, oh my God, you did this, you did that. That is not enough for appeal. You must show that evidence wasn't submitted, that something wasn't done, there was some type of a procedural error, such as the juror getting thrown off. However, that is not enough. That's just half of the qualification. You must show without a shadow of a doubt that if that error hadn't happened, if this person had testified, if evidence wasn't concealed, if that juror number 6 wasn't removed, that the jury would have found you not guilty. It is almost as much as Diddy is going, and his people are going on this media campaign, trying to act like they're holding all the cards. Baby, this is Diddy's MO. He's always doing smoke and mirrors, right? As much as they tried to act. Basically, what's going on is that, fine, maybe you can argue juror number 6 shouldn't have been dismissed. I think the judge made the right decision, but let's just say you could make that argument, okay? Where are you making the argument that because juror number 6 was dismissed, there was an effect on the jury, and that made the jury move in another direction? You and nobody should ever, because here's the thing, the jury is not supposed to talk about the case while it's happening. They're not supposed to talk to each other. That's why when people see whispers, when people see this, when people say that, everybody gets a little nervous, like, what are you guys doing talking? Now, you could be asking about the weather, or you could be like, yo, I don't think this mofo's guilty. The point of the matter is, since the jury legally is not supposed to be talking about the case, how can you prove by getting one juror removed in the middle of the case, right? In the middle of the case, how can you prove that that is the reason why a jury found you guilty? How would you know? What is in that juror's mind? Now, here's the thing, and this is the major mistake I think Diddy's team made. This trial has been on the up and up. I believe the jury is acting in good faith and is on the up and up. But does anybody not think it's interesting and just a little weird, right? A little weird that Diddy had all these people. He was going to put on the defense of the century. He was going to do all this stuff. Nobody thinks it's a little bit weird that after juror number 6 got dismissed, Diddy's whole defense just fizzled? Diddy's whole defense just said, never mind. And now they're acting like juror number 6 being dismissed literally is the linchpin of the case. How could you know what a difference juror number 6 would have made? How could you know? Well, how could you know? They're not supposed to talk about it to other jurors. They're not supposed to talk about it to their family members. They're supposed to keep their minds, their thoughts in their head. So how could Diddy's team come out and say, we know for a fact that juror number 6 was so pivotal to the case that it changed? And again, it's weird the way that just last week, Diddy's team said, just last week, no, 2 weeks ago, Diddy's team said that they were going to have a 4-week defense. They said that they gave the prosecution a list of witnesses that were going to testify that was so long, the prosecution was like, this isn't even in La La Land. Like, there's no way that we can finish this case in 4 more weeks with these witnesses. It would at least take 2 months. You went from that to fighting over the jurors. And when we didn't know whether, we knew juror number 6 was dismissed, but we didn't know whether juror number 7 and 8, Diddy was trying to get either number 7 kicked off or even number 8. I'm just using numbers. I don't know if that's their actual numbers, but there were 2 people that were a mystery to us that they were trying to get kicked off because they wanted this alternate juror to come down, okay? Now, and they wanted either 7 and 8 and maybe even both kicked out. When that fight was going on, and they were still fighting for juror number 6, they were like, the judge was like, how long is your defense gonna be? And they were like, honestly, maybe 3 to 5 days. And I said, how did you go from 4 weeks to 2 weeks to 3 to 5 days, all because of a juror? Then, once they found out that juror number 6 was gone and the judge wasn't revisiting it, and then once they found out that juror number 7 or 8 was not going anywhere, and again, I do not know if those are those numbers, I'm just saying it. Hey, Mary Briggs, thank you so much. Once they found out, all of a sudden your defense goes from not even, now you don't have any witnesses, and you're not even gonna put on the defense for 1 day, and what you do is you're going to read text messages, which makes me believe that if you could, you would do nothing, but you know you just can't do nothing, so you're just gonna read text messages? Does nobody see that that is very weird? And it is a major mistake. As much as Diddy's team wants to talk about juror misconduct, this, that, and the third, as much as Diddy's team wants to talk about, oh my God, how dare, it's not, there's a lack of candor, there's this and that. How are you literally pointing something that looks like you felt like juror number 6 had more sway, pull, and importance than anyone could have known, anyone could have guessed, and honestly, if everybody had been following the rules, more than anybody, more than they should have had. More than they should have had. It's very, very odd to me. And it's weird I think this is a huge mistake for them to try to use that as the grounds for acquittal, for mistrial, for appeal, whatever they're gonna, well, they won't use it for acquittal, but they might. They might. No, they can't use it for acquittal because that has to be with the evidence. But for a mistrial, for an appeal, for anything, or even with the renewed motion for summary judgment. Renewed motion for acquittal. I find it very, very odd that Diddy's team is pointing a finger at something that, even if everything you're saying is true, even if everything you're saying is true, does it rise to the level of a procedural misconduct? Yes, you can make an argument, because you can make an argument for anything. You see Diddy's minions in the news. You can make an argument for anything that juror number 6 shouldn't have been dismissed. You can make an argument for that. But how can you make an argument that juror number 6 was so pivotal to your case that if you got let off, if the juror number 6 had stayed there, then you would be walking free? How could you do that? And why is it after you found out that juror number 6 was going to be dismissed that you literally threw your whole defense out? And now you don't want to testify, and this is after weeks and weeks and weeks of them saying, get ready for the rumble. And now we find out that nothing is actually going on and nothing is happening, okay? So, let's get back into this, right? Also, let's not forget, prosecutorial, I can't even say the word, misconduct. We need to talk about that. Diddy's team has tried to make over and over and over, the prosecution didn't do a good investigation. They overreach. They do this. Remember how everybody was asking, what about the kids? How come they're not testifying on this? How come they're not bringing them up on charges on that? I'll tell you why. Because Diddy's done a lot of dirt. Everybody that knows him or knows about him seems to feel the same way. There's a lot of stuff they're not bringing in a trial. Now, what exactly it is, that's up for the debate. But there's a lot of things that people think that they can bring him up on and they haven't. Why is that? Because this is not a district attorney. This is why Brian Steele, Westmoreland, Xavier, he's from the Southern District there, have been largely very good, but ineffective. What does that mean? Through no fault of their own, because they're used to DAs, they're used to overcharging, they're used to, here's what it does, right? Police arrest you, and then they investigate, okay? They finish their investigation. Now, Diddy is in jail for being arrested, but that's because he was doing like obstruction of justice. The feds investigate you, and then they arrest you. But again, I said the feds are like an anaconda. By the time you know an anaconda is around you, you're not escaping. It might have taken them forever to get there, but you're not escaping. As opposed to district attorneys are like lions. They chase the gazelles. They chase the little baby antelope. However, sometimes they escape. It's not a sure shot like it is with an anaconda. The odds of a little baby antelope escaping a lion are much higher than a little baby anything escaping an anaconda. Now, it could happen at 0.001%. The feds do not overcharge. That's what they're known for. They try to get you on airtight charges. Do I need to get you for, and I'm just using an example, the feds are like this, do I need to get you on murder when we have evidence of it, but it's going to be an argument to the jury to prove it? And murder will get you life. Or do I get the same person that I think is guilty of murder? Do I get you on sex trafficking? Do I get you on RICO? Do I get you on conspiracy? They're both going to give you life, but one I can prove without a shadow of a doubt. And the other one, it's going to be an argument back and forth. That's what Diddy's team was hoping. They were hoping Diddy would be overcharged. They were hoping that the feds would go crazy. They were hoping that the feds would file charges like they are district attorneys. And this is no shade about district attorneys. This is just the way it goes. You can't forget that the district attorneys do not have the resources and the investigation unit that the federal government of the United States does. They are very limited, which is why they go about things procedurally. My point of the matter is, they did not overcharge Diddy. They got him on 3 airtight charges that nobody can deny, even though they're trying to act like it. And you can throw all the motions you want out there, it's not going to mean anything. But they've also been making things about racism, prosecutional misconduct, this, that, and the third. And the judge has been addressing it. Now, some people are like, oh my God, this is ridiculous, But there is a method to Diddy's madness. See, they wanted those things to hang out there. And they wanted to keep making these snide remarks and motions. Yeah, because we ain't never seen nothing like this. They should be ashamed of themselves. What is this? Does this law exist anymore? And they were hoping that the judge would ignore that and they could have that preserved emotions. So when they go up to the appeal, they can say, we always thought that there was misconduct. That was never, ever, ever addressed. However, Judge Aaron and the prosecution have been on top of Diddy's head. They see what the defense team have been doing. And the judge, sua sponte, that is just literally just on his own, has been addressing the claims of prosecution misconduct, racism, targeting, unfair, this and that. He has addressed it all. They've done investigations and they've said, we see no evidence. The prosecution has outright addressed it too. But what does that mean? And why is Diddy's team so upset about that? Because you guys understand, when it comes to appeal, they look at the record, okay? When it comes to appeal, they look at the record. And when the record already addressed stuff, does investigation in that moment, because we see from Diddy, right? You can do investigation, but it's always better to investigate in the moment because the evidence is fresh. This is fresh. The other side can respond back. As opposed to waiting till this trial's over. They say all this stuff about prosecution misconduct. Diddy's like, it's A. The feds are like, no, it's B. But the appeals team has to be like, well, hold on. It's a little bit unclear. We're going to have to conduct an investigation. No. The feds and the judge are making Diddy stand by everything he's saying. They're saying, we did our investigation, we see no proof. No proof. Do you have proof? Diddy's team is like, well, we feel. He said, yeah, I know you got feelings, but do you have proof? And they've had to stand in front of every pointless motion and saying, okay, well, we really have no proof. This is what we are feeling. And the judge has said, and ruled, well, based off of your feeling, it's still not prosecution misconduct. What does that mean when they go for a appeal and they try to say that the prosecution was corrupt, they were racist, they already have it in the ledger that those points have been addressed. It has been proven false, so they can no longer use that as grounds for an appeal. Again, all this stuff that's floating on social media that everybody's been so quick to grab onto, they've already adjusted, and it's just not happening. Tanya Reyes said, hey, Tisa, I wanted to take a moment to express my appreciation for keeping me in the loop. Oh my God, on the latest news of P. Diddy. God bless you. Thank you, Tanya. I appreciate you so much. Listen, again, these motions will be denied over and over. Just like these accusations of misconduct will have and will keep getting denied. But again, Diddy's team is more upset than you think because they were hoping that they could kind of slip under the radar. It's almost like the slick shit they do in court where they'll literally whisper into the microphone, objection, Your Honor. The objections aren't just to stop the prosecution's flow. It's also to put on the record that you objected because it could be grounds for an appeal. So usually they're like, objection, Your Honor, objection. Sometimes when they want to let shit slide because they think it might be good to muddy the waters in an appeal later, they'll whisper, objection, Your Honor. Not even in the microphone. But Judge Aaron, he got ears of steel. He'll be like, wait, stop. He'll stop the testimony and be like, wait, was that an objection? And they'll be like, oh yeah, and he'll be like, grounds. Again, they've been trying very, very slick stuff, but Judge Aaron is by the book and he's been doing everything he can to make sure that they just can't get this overturned on procedural or prosecution misconduct. Oh, Yolanda West, thank you. You said Tisa, Walter Cronkite would be proud of you. Yo, they've been whispering objection because they're hoping that when they go, they can be like, no, we objected. Because again, Diddy's team thrives on confusion. They can't stand on the facts. They can't, and everybody's a Diddy supporter. You can't stand on the facts, right? Yes, Donna W said, feelings aren't facts. Thank you, Tisa. Diddy's team cannot stand on the facts, so they are being forced to use a cloud of confusion. And again, what's the best thing for confusion? To start looking into something years, because an appeal could take a year or two to come up. Years or even months after it happens, instead of addressing it in the moment. And they don't want to address everything in the moment because they know they have a better chance to deny, delay, confuse, conspire, to get their point across and argue a case. And that's why the judge has been so on top of it, saying, wait, did you object? What'd you do? And everything they put in their letters, even the throwaways, even if they're not asking him to rule on it, he will address it, he will investigate it, and he will rule on it. So congratulations. And I think this is why Westmoreland, Brian, so actually all of Diddy's team, and as much as I say, Yana, if I had the money, I would 100% want Mark, Tinney, Xavier, Westmoreland, and Steele. I would want them 100% on my team if I could afford them, right? Do I think their antics are ridiculous? Do I find it disgusting that they're trying to get this guy off? Of course, but you know, with defense attorneys, baby, it's just defense attorneys. They're not morally bankrupt, but they have to give everybody the same defense, whether you are innocent or guilty. That's why. But the point is, I would 100% hire them because they are very, very good at what they do. But in this case, with this defendant and this judge, and this prosecution, and in this Southern District in New York, they do not have any wiggle room. Again, they can't win on the facts, so they're gonna win on whatever they want, okay? Listen, again, feelings are not facts. Procedurally, and that's what you need for an appeal. Procedurally, okay? You need, for an appeal, you just can't go and be like, nah, and I think the jury was wrong. Unless there's something called jury nullification. Unless the jury said you were guilty and there is video showing you were 100% innocent. That can happen. It's called jury nullification. That's when the judge overturns the jury's verdict because there's no way. That's not happening here. But again, when it comes to procedural error, it's not just enough to show that something wasn't shown, that something didn't. You must show that something didn't happen, and because that something didn't happen, you would have been found not guilty. With this type of mountain of evidence, it's impossible. That's another reason why, as much as people think it's boring and I am people, of these summary expert witnesses, it is a necessary thing because it gives, hey, good morning. Now, do you rest?
Yeah.
Cody Code 39 said at this point you could give the closing for the prosecution. You're so good. Thanks for the daily updates. Oh, Cody.
Yeah, she
Cody
rocked.
Code 39, thank you.
She's rocking this thing.
You must show that not only, but that's why the feds are being so smart. Listen, Yolanda West at TISA, you are dealing in facts just like Cronkite. Thank you so much, Yolanda West. But again, getting into this, you must show that you would have had not guilty because the feds are showering us with evidence. Even if it's A, you still can't prove that that would have gotten you not guilty because they are giving a mountain of evidence to show. You must also show newly discovered evidence, but that newly discovered evidence, it can't be like, oh my God, I just discovered, they said it was the 23rd and it was the 24th. That's not newly discovered evidence. Again, it is that two-factor thing. Yes, it must be evidence that was not presented in court, but it must also be evidence that if it was presented, a reasonable person, beyond a shadow of a doubt, would have found you not guilty. So me finding out that they showed a receipt that said the 23rd and it was actually the 24th, that's not enough. You must show that because it was the 24th and that was supposed to be the day of the murking, that there's no way you could have done it. It needs to be evidence that can guarantee a not guilty for the appeals court to actually get into this, okay? And of course, we already talked about that prosecution misconduct, right? Now, let's just say this. The prosecution, and I made a little example for everyone. Let's just say the prosecution, they finished presenting their case, okay? The defense makes a Rule 29 motion saying there's no evidence my clients knew the drugs were in the trunk. The judge denies it, and the judge lets the case go to the jury. So let's just say that Diddy's like, there's no evidence that because part of being in a conspiracy is you need to know you're doing it. Now, you might not know how illegal it is, but you need to know that you're doing this and furtherance up. See, here's the thing, right? The people don't need to know, we're all criminals. All they needed to prove was that Diddy's team knew that by doing this, you were helping the Combs enterprise. You were doing this in furtherance of the Combs enterprise, all right? Thank you, Barbara Monsinger said you've definitely done your research. Thank you. Thank you, Barbara, okay? Listen, they said, so let's just say the judge denies it and he lets the case go to the jury. Let's just say, and speak it into the universe because we 100% think this will happen, the jury convicts Diddy of guilty. Now that's when the defense will renew the Rule 29 motion after the verdict and saying there is still no evidence of knowledge. Now if the judge agrees, the verdict will be vacated and the case is dismissed, okay? Cindy Marbury, thank you. This is what Diddy's team is hoping on. This is why these summary witnesses, I don't want to use the word boring, but it's a lot. It's a lot. It's a paperwork jungle. And you know how I feel about paperwork jungles. It's like being in a DMV in hell when you have to listen to them do a presentation. However, it's a necessary evil because they are showing that this Rule 29 motion that they must do when the prosecution rests, they must renew when the defense rests, and that they will renew after a guilty verdict within 14 days saying there was still no evidence of knowledge of the RICO or anything he's found guilty of. If the judge agrees, the verdict could be vacated and the case could be dismissed. The prosecution, by drawing us in this evidence, has made it a 100% improbability that you will be able to say that because not only does any evidence exist, all evidence exists. And by that, I mean all evidence exists. Hold on, they might be letting us little people in. Okay, all right, you guys. I'm going into the court. Am I going to the court? Yeah, I'll talk to y'all later. We're going inside. I got to fight for my thing. I'll talk to y'all later. Bye.
Bye. Yeah. I want to do a little bit of my man. Watch this right here, y'all, real quick.
J.I. Tools now. I want to know how our sounds is sounding.
On go.
How is we finagling? Salute.
Uda got himself my man got himself a press badge.
29. Make sure y'all can hear him clear. I got this good mic on and I want to make sure. Say yes, I hear him good.
Okay, all right. He interviewing people and stuff. I do one more of his videos or something. But Tisha Tales.
And we are talking.
Tisha Tales is giving it to you straight with no chasers, man. Y'all let me know what y'all think, man. I don't think. Dude, I already know. Well, I included from beginning to end, from the rooter to the tutor. I really think that once Diddy is found guilty, you know, oh, that's bull, and all this stuff. The lawyers, they're going to appeal. They got to appeal, man. That's how they're going to get more money out of him. And you know, they hyping him up, thinking that he's winning. And dude, it's clear that you know what you did. Hey, I'm gonna get on up out of here. Y'all take it light, take it slow. Tell them Uncle Mike told you so. Peace out.